After a 13-day trial and less than a day of deliberations, the jury has decided the fate of 3 men accused of killing Ahmaud Arbery. The 25-year-old black man was fatally shot in February of 2020 in Georgia by 35-year-old Travis McMichael. His father, 65-year-old Gregory McMichael, was with him at the time that this happened, as was their neighbor, William Bryan, who captured the incident all on video. Now, the trio suspected Arbery of stealing from a construction site and say they followed him in a pickup truck, which ended in his death. Now, they each faced 9 criminal charges, including malice and felony murder, aggravated assault, and false imprisonment. Now, the verdict in this case, the McMichaels have been found guilty of all counts and Bryan guilty of all counts except malice murder and 1 count of aggravated assault. Now, to break all of this down for us, we are joined now by law expert and professor Joshua Kastenberg. Thank you for speaking with us today, Professor.
And thank you for having me on.
All right, so let's get right to it. Overall, what do you make of the verdict?
Well, there was a lot of speculation on what it would mean to have a jury in which the defense counsel managed to have persons of color removed from the panel to the point where the jury consisted of 11 white citizens and 1 African-American citizen. What I take from this is that although the prosecution and the judge sought to remove race as an issue throughout the trial, it was central to the trial. And yet the jury weighed the evidence. They found all 3 men guilty beyond a reasonable doubt, which is the highest burden of proof on a prosecution in any country in the world. And they did so unanimously. 2 of the defendants were found guilty of felony murder, and 1 was found guilty of malice murder. Those are both first-degree murders, but I think that one could assume that there's a higher likelihood of parole or a slightly reduced sentence with a finding of felony murder. And the reason for that is felony murder does not denote premeditation or hate. It denotes an utter degree of recklessness in the commission of another violent felony, which results in a murder. I know that's quite a bit of a legal tangle, but that's what makes felony murder different than premeditated murder or other types of murders. Nonetheless, these are 3 very, very significant findings of guilt on all 3 defendants.
Now, the defense argued, we know, it was, for their clients, they acted in self-defense, they say. Meanwhile, the prosecutor insisted that the men provoked the fatal confrontation. This was less than a day of deliberations. How much of a clear-cut case was this?
Well, I followed this case from the beginning. And in my own, I teach criminal law, and you can teach the principles of criminal law. And if you apply the principles to the facts of this case, it was very clear-cut. Of a sign of guilt for the following reasons. The 3 defendants did not know Mr. Arbery. They had no reason to specifically suspect him of committing a crime. They targeted him because of some loose degree of reporting out there that there had been burglaries in the neighborhood. He wasn't appearing to commit a crime, and certainly whatever he was doing, it was nonviolent. He was chased by the 3 men, and they essentially hunted him down. And so even if you take Georgia's citizens arrest law, it's post-Civil War citizens arrest law, which is still on the books, by the most liberal interpretation possible, it was always clear cut to me that the 3 men were guilty of what they were charged with. And many people I've talked to in academia and my students as well, having said that, there's a difference between something being clear cut to a professor than there is with a jury often. And on this point, I would say that the jury applied the judge's instructions as a correct reading of Georgia state law, and they arrived at a result that was the right result with the highest burden of proof placed on the prosecution.
And Professor, there were 3 defendants on trial. Each of them had a very different role in the incident. So how would that have impacted, or how could that impact a jury's deliberations?
Well, you have to make sure, as a former trial judge, I was confronted with this myself. You have to make sure that when you instruct a jury, that the jury can only find each defendant guilty based on the evidence that strictly applies to them, that particular defendant. And also each crime each offense has to be judged on its own so that there's no impermissible spillover, which is a term of law that we use in the United States and other areas of the world. Having said that, you want to make sure that the jury is very clear that they can acquit one and find other defendants guilty or vice versa. Given that one of the defendants was found guilty of a lesser charge, and given that felony murder was on the books and how the jury treated that, I'm confident that the jury followed the instructions of the judge.
All right, we know the instructions were a lot, I think, they were a lot clearer, less convoluted than what we saw in the Kyle Rittenhouse case. And so the jury deliberations, as we keep mentioning, less than a day. But this case, as we know, and you've sort of mentioned this, it's been very racially charged, and it gained attention nationwide and beyond the borders of the United States. There have been marches, there have been protests in Arbery's name, demands for justice. So how much of an impact do you think all of that had on the trial, and could it really take place without any bias being involved?
Well, I would hope. It's very, there are histories in our country and around the world of well-documented trials that get world attention. You can go back to Sacco and Vanzetti after World War I. You can go to the Dreyfus case in France in the late 19th century, and you see a worldwide outpouring of support either for the defendant or for the cause of justice. You never can be sure. But given the way the jury in this case was composed and protected, I'm as confident in this particular jury and its application of the law to the facts and in its result as I could be of any jury in the United States. I'm not casting any aspersions on the Rittenhouse jury or the judge, but what the world should understand is these are two completely different trials. The Rittenhouse case involved whether or not under Wisconsin law someone can put themselves into a peril and still claim self-defense. And central to that issue is whether or not Rittenhouse contributed to that peril. And if the jury found that he didn't, then he was acquitted. And that's what the jury did in that particular case. The case in Georgia has completely different facts. It involves three individuals who decided to take the law into their own hands. And they corralled Mr. Arbery, and even taking them at their own word, which is difficult to do, but let's say we could for a moment. Arbery tried to defend himself, and they killed him. And whatever the jury thought of that, they certainly applied the citizen's arrest law as well as the law of self-defense in Georgia to that case. And they arrived at the conclusion that these three men operated outside of the law and they engaged in vigilantism that resulted in murder.
All right, so what could be next for the three defendants, for the three men now? Now the guilty verdict has come down for the McMichaels and for Brian. Are they able to appeal this?
Absolutely. There are several stages of appeal. First, they can try to appeal to the trial judge, and they can argue that the trial was unfair because of public pressures. Although what I will say about that is the law is pretty clear that when the defense counsel contributed to the public pressures, two of the defense counsel made some very, very racially charged statements throughout the trial, and that resulted in an increase in interest in the trial. I don't believe they'll be able to claim because they contributed to that public interest that the trial was unfair. So then you have two sets of appellate courts. There's the Intermediate Court of Appeals in the state of Georgia, then there's the Georgia Supreme Court, and of course there's the possibility of what's known as habeas appeals to the federal courts, and then finally onto the United States Supreme Court. But what's next for this three defendants also is the possibility of facing a federal trial on the deprivation of civil rights, which would be a criminal trial in the United States District Court. And the three men have been charged, and there is a trial date docketed, so they may face a second round of trials in a different sovereign under different crimes, which means that this is not double jeopardy, but their place in the courtrooms of the United States is far from over.
Exactly what I was about to say. It's not over yet. Well, Professor, thank you so much for your time today. Well, really appreciate your insight.
Thank you.
That's law expert and professor Joshua Kastenberg.